Well, good afternoon, everyone. So good to see you. Please come in when you can. Get a chance, hit that like button or that thumbs up button if you can on your way in, on your way out. Today we're going to talk about a very different Texas death row inmate. It is a female. Her name is Brittany Holberg. She's been there 27 years. Now, our other death row inmate, who just got executed last Thursday, was only there for 19 years. Oh, shit. For 19 years. So why is it that Brittany Holberg is sitting over here at 27 years? Why do some people go for 27, 25, 30? What is the difference between all these people? Why do some people sit longer than others? This is something I really don't understand, and I really think that it should be the same. Let me plug this in. I forgot to plug in my damn tutor. I don't want it to die on me. So here we go. There we go. So I don't know why some people are on death row longer than others, but we're going to talk about it. I also wanted to visit about James Broadnax, and because I put a little thought out there, everybody. I asked, should they all get the same time for the same crime, or should it be depending on the crime itself? You know, there's a lot of different answers that are coming from that. And then I put out there, was Texas wrong? Did Texas get it wrong with James Broadnax? Some people said yes, some people said no, and then some people had some very strong opinions on it and told me I was wrong. Now, the reason why I'm asking, and I'm a proponent of the death sentence, I am, but I think because Mr. Broadnax's cousin, his DNA was on the gun, his DNA was on the person, and in the end, he says he was the one that did the shooting, not Mr. Broadnax. I think they could have taken 30 days to kind of look at that, but I don't know. We'll see. Oh, my mosquito bite showing a little bit. Yes, I was outside and got a little mosquito bite. Anyway, yeah. So let's go ahead and talk about what happened with Brittany Holberg and why is she in prison on death row now for 27 years. So let me share my screen, guys. Hope you had a wonderful weekend. Hope you enjoyed the nice weather that we all had. It was nice here. So let me share my screen here. And I'm going to go back over here. All right. Now, make sure you can see it. All right, there you go. Now, I'm going to pull this up, and I'm going to read a little bit about how this happened. Brittany Marlowe Holberg. She was born January the 1st of 1973. She's an American woman that's on death row in the U.S. state of Texas. On Friday, March 27th, 1998, Holberg was convicted of the November 1996 robbery, torture, and murder of an 80-year-old A.B. Towery Sr. in his southwest Amarillo home. Although she claimed it was self-defense, Holberg's conviction was again overturned in 2025, but was reinstated several months later to allow for a rehearing. Okay, this is a little different, isn't it? Holberg killed A.B. Towery on November the 13th, 1996, after a fight. According to Holberg, Towery had been paying her for sex for several years prior. On the day of the murder, Holberg testified that Towery had attacked her with a frying pan after discovering her smoking drugs in his apartment. She claimed to have struggled with him for several minutes until she pulled out strands of her hair. He pulled out strands of her hair, at which point she lost it and stabbed him several times before shoving a brass pole down his throat. Trigger warning, this is extremely violent, okay? In this story, it is extremely violent. Trigger warning, trigger warning. I don't know how you can shove a brass pole down somebody's throat. And I have a lot of questions about this because how did she just so happen to have a knife in her hand that when he pulled out her hair, she was able to just start going after him with a knife? There's parts to the story that do not make a lot of sense, and we're going to discuss it all. So hang on a second, guys. Let me go back over here. Now, prosecutors claimed that Holberg had killed Towery in order to steal his money and prescription drugs, which made the murder a capital offense. Evidence of this theory included Towery's wallet, which was found open at the crime scene, and the testimony of two witnesses who had seen her counting money in the aftermath of the killing. After killing Towery, Holberg fled to Tennessee. She was arrested in Memphis in February of 1997 and extradited back to Texas. At her trial, Vicki Kirkpatrick, a confidential informant of the Amarillo Police Department, testified that Holberg had admitted to her that she had murdered Towery in order to steal from him. Now, here's another questionable situation in this murder trial. When you have confidential informants that work for the police department, um, are they credible? That's a question, isn't it? Are they credible? Because sometimes I don't believe they are credible. Because you have to think about what their role is. They are planted in cells with other inmates to get them to talk about stories or to get to them to talk them into admitting whatever the story or whatever the narrative the cops want it to be, right? Because we know that cops are not always honest. We know that. We've seen it many times. However, I still believe in law enforcement, and I believe that for the most part, law enforcement officers do their job and they do it with respect and honesty. So let's go back and look at this some more. Um, so now just a second. So we have an informant. She claims that Holberg described the killing as fun and amazing and had expressed a willingness to kill again. Kirkpatrick later recanted her testimony in 2011, claiming that the prosecutors had coerced her into testifying against Holberg by threatening her with a pending burglary case. That is possible. Holberg was found guilty of murder in the commission of a robbery and sentenced to death. Now, this is exactly what happened in the Broadneck's case. Because it happened in the commission of a robbery, Mr. Broadneck's and Mr. Cummings, their targets, they had murdered someone. So that is why they were both charged with capital murder. Anyway, let's go back over here. So, one of Towery's sons later recalled that he had smuggled a gun into the courtroom in order to kill Holberg during the trial, but had changed his mind at the last second. So her own son wanted to take her life. No, that's not what it says. I'm sorry, guys, it's not what it says. One of the victim's sons had smuggled a gun into the courtroom in order to take Holberg's life during the trial, but had changed his mind at the last second. That's pretty serious. Holberg filed an appeal in the Court of Criminal Appeals of Texas, but on November the 29th, 2000, the appeals court upheld the decision of the trial court. So she was affirmed that she was still on death row. In 2015, James Farron, the district attorney of Randall County, stated that due to the legal complications involving the Holberg case and the resulting legal expenses, he estimated the cost that was about $400,000 and time expended. He would pursue life imprisonment without parole for future capital murder cases unless there was an exceptional circumstances. Now, that I don't really find that to be fair. Because if all of a sudden you're going to take the cost of trying these cases into account versus the crime that they committed, but you still have other people on death row in your county from the same type of offense, you weren't concerned about the money then. Why are you concerned about the money now? You see, it's not balanced. It doesn't make sense. So there's all kinds of little parts of this case that make it difficult, and questionable. So, in March of 2025, the United States Court of Appeals for the Fifth Circuit overturned Holberg's conviction after they found that the prosecution had not disclosed Kirkpatrick's status as a paid informant during the trial, which they concluded was a violation of Holberg's due process rights. Circuit Judge Kyle Duncan dissented from the majority's ruling, writing that the conviction was not based solely on Kirkpatrick's testimony. Duncan stated that the physical evidence alone would have been sufficient to disprove Holberg's claims of self-defense. Holberg's case was referred back to the trial court for further proceedings. However, in July of 2025, the Fifth Circuit reversed its prior ruling and granted a motion by the state for rehearing en banc, meaning that Holberg's conviction was reinstated and the appeal argued again before the full court. The rehearing occurred on January the 21st of 2026. Holberg's defense argued that Kirkpatrick's testimony was the only evidence of her alleged sadism and her intent to rob Towery, and thus she should not qualify for the death penalty. They also argued that Holberg's trial attorney had failed to present mitigating evidence, such as her family's history of mental illness. Now, this kind of reminds me of the case that's going on right now on the ward case studies. Everybody's watching the Tanner case where he took the life of little 7-year-old Athena. And there's a lot of mitigating witnesses on the stand to try to stop him from getting the death penalty. This case reminds me of that. Now, except it was an 80-year-old man. In response, the prosecution stated that Towery's extensive injuries indicated a degree of sadism, and Holberg herself had discussed the mitigating circumstances when she testified at her own trial. Holberg, this is her personal life. Holberg has spoken out about the death penalty, abuse in the Texas Department of Criminal Justice, and the need for better prison conditions in a 2001 letter written to the Canadian Coalition Against the Death Penalty. Holberg said, "Just 2 weeks ago, we were informed that not only would we be strip searched for our 1 hour of recreation a day, but also when taken for a shower. So the last 2 weeks, we have been stripped no less than 6 times a day, and our cells have been completely ransacked. This is every day, sometimes like at 2:30 or 3 a.m. We never leave the building, ourselves for that matter." She has also written on behalf of other prisoners, such as a 60-year-old murderer named Betty Lou Beats. In 2003, Holberg was interviewed by Mrs. Magazine about her life. She had married as a teenager and in 1993 gave birth to a daughter. At the age of 20, Holberg moved back to Amarillo, her hometown, and subsequently fell in with a bad crowd. In a Dallas Morning News account, Holberg was described as a woman who was exposed to drugs at home when she was only 13 or 14 years old and had married before she completed high school. After the dissolution of her marriage, she became addicted to drugs and confessed to scamming prescription medication from the dentist with her aunt. Holberg was caught with drugs and was released from the state custody after completion of a substance abuse felony punishment program on September 1st of 1996. Holberg had also been gang raped, severely beaten, and cut with a knife. She was hospitalized after that incident. Holberg was mentioned in the January 2007 Maxim magazine's article titled Babes Behaving Badly, which featured 10 women convicted of crimes. Holberg is one of the 7 women on death row now in Texas as of December 2023. So let's go back. Now, this is how it all started. This was her crime, and she's discussing how bad it is in prison, and we all know that they all feel like their rights are violated multiple times every day. There's not going to ever be a death row inmate that's going to be completely satisfied or happy with the conditions that they're living in. We understand that. So we are going to look at her appeal, and then we're going to go watch the oral arguments from her appeal that happened this year. So let's take a look. We got to go out to the Court of Appeals. Hang on a second, guys. Just bear with me while we pull this up. Okay. Brittany Holberg's. Brittany. Okay. It's over on Justice. I believe it's on Justice. So let me pull this up over here. Here it is right here. Okay. So let's take a look and make sure you can all see this. Let me share the screen. I'm going to get rid of this right here. I'm going to share the screen again to show you her appeal. And we're all going to just look through it, look at the summary, and then we're going to go watch the oral argument. Okay, here we go. So, put this down here. Make sure you can all see. There we go. Looks good. All right. Now, come on now. This was filed March 7th of 2025. I'm going to pull this up. Remand this case to the district court for further proceedings consistent with this opinion. So this is going to be this opinion. Before Higginbotham, Higginson, and Duncan, Circuit Judges Patrick E. Higginbotham and Circuit Judge. Brittany Marlo Holberg was 23 years old when she was sentenced to her death for capital murder by a jury in Amarillo, Texas. Holberg had spent the last 27 years of her life on death row, contending that the state of Texas violated her right to due process when it chose to disobey the commands of Brady versus Maryland. Now, this comes back, and we talk about this a lot in some of these cases, the Brady violation. This is when the prosecutors failed to turn over evidence to the defense that would possibly have came out with a not guilty finding. So that is a Brady violation. Here we go. So it failed to disclose impeachment evidence that is critical to a trial witness that was a paid informant. Under Brady, its progeny, we reverse and vacate Holberg's conviction and remand this case back to the district court for further proceedings consistent with this opinion. We pause only to acknowledge that 27 years on death row is relatively dimming the light that ought to attend proceedings after a life is at stake. A stark reminder that the jurisprudence of capital punishment remains a work in progress. The death penalty itself has traversed a torturous path in this country, dragging Ms. Holberg along with it. From the return of capital punishment in the 70s, paired with the veritable flood of habeas petitions, come attended efforts to temper the flow. In the service of federalism and management, Congress enlisted the aid of the lower federal courts by routing review of state decisions to the district courts through the gates of the Anti-Terrorism and Effective Death Penalty Act of 1996. Yet capital punishment cannot survive without the adherence to the fundamental constitutional guards securing the right to trial by jury. Ms. Holberg's 27 years on death row is a showcase of the state's failure to abide by a core structure of prosecution, the Brady Doctrine. Let me look at something really fast. Okay. This is the story of Brittany Marlowe Holberg, a bright young woman who, after a childhood of adolescence marked by repeated sexual abuse and trauma, fell into the iron grip of the crack of cocaine and turned to prostitution to support her addictions. Okay. On November 13, 1996, after 10 consecutive days high on crack cocaine, Holberg had a minor traffic accident and sought refuge in the apartment of a former customer, A.B. Tower Sr. A heated argument followed that quickly turned into violence, leaving Towery dead with stab wounds as part of a lamp in his throat, and with Holberg leaving the apartment cut and bruised, bleeding from the head where Towery struck her and tore out clumps of her hair. A crime scene investigation was performed on November 14th and an autopsy report completed on November 15th. Holberg was arrested in Memphis, Tennessee in February of 1997 and was extradited to Amarillo, Texas, where she was held in the Randall County Jail. There, the local district attorney's office unsuccessfully approached multiple inmates, including Holberg's cellmate, to question them about Holberg and offered them deals in exchange for the testimony against her. The prosecution also attempted to feed them false narratives. One of Holberg's cellmates, Lynette Tucker, stated that she never heard Holberg boast about the death of A.B. Towery, but the prosecution told her that it would be in her best interest to say that she knew Holberg longer than she did and that Holberg bragged about this killing. That is not fair. About 3 months after Holberg's arrest in May of 1997, Vicki Marie Kirkpatrick was arrested for felony burglary. At the time, Kirkpatrick was working as a confidential informant for Corporal Eddie Stallings of the City of Amarillo Police and was placed in the same cell as Holberg. Just 2 days later, Kirkpatrick produced her statement to the Amarillo Police detailing Holberg's alleged admissions. Crucial details in Kirkpatrick's affidavit corroborated findings from the autopsy report and the crime scene investigation, which had been with law enforcement for 6 months. The same day, Corporal Stallings secured a dismissal of the criminal trespass charge against Kirkpatrick and helped her gain release on bond. But Corporal Stallings left that felony burglary charge pending until after Kirkpatrick testified against the Holberg. Now let's talk about this for a second. Does that seem fair to you? Does that seem like she was a credible witness? Does that seem like she should have been believed in a jury trial? In my opinion, the answer is no. I don't think so. Because the one thing we know about this, if you are facing jail and somebody offers you a deal that says, I'm going to get rid of that charge and I'm going to help you get out and we're not going to follow through with that charge, are you going to lie or are you going to tell the truth? Most of the times, these people have criminal records already and they don't want to go back to jail, or they've been to jail before and they don't want to be there. So yeah, they're going to say what they need to say. And this is really questionable in this case because it was 5 years later she recanted the whole story. Of course, her charges were already gone by then. Of course she could recant it and there would be no she would not get in trouble for recanting her story. There was nothing more they could do about it. So here we go. So at trial, Holberg stated that she had an ongoing relationship with Towery in which sexual favors were exchanged for money, and that there were times when he got angry and frightened her. According to Holberg, Towery would get angry if he had a hard time performing or if he thought she was on drugs with him. Regarding the encounter, Holberg asserted that she acted in self-defense when Towery attacked her, testifying to the following sequence of events. High on crack cocaine, Holberg wrecked her car and sought refuge in Towery's apartment, meeting him by the gate as he was coming back with groceries. So it was just a chance meeting that happened, and all of a sudden she's staying with him. That does not sound it does not sound like Mr. Towery had very good judgment. But we don't ever blame the victim. Towery invited her into his home and began unpacking his groceries. When he later saw her crack pipe in his kitchen, he became angry, screaming, "You stupid bitch whore! What do you want? You want money? Is that what you want? Or do you so you can smoke the rest of your day away?" Holberg then heard Holberg then heard Towery approaching her from behind, and the next thing she knew, he struck her on the back of the head, then shoved her to the floor. And at some point during the struggle, Towery pulled money out of his wallet and threw it at her. When Towery pulled Holberg up by her hair and refused to stop, even after Holberg had asked him to let her go, Holberg stabbed him to protect herself, fearing her life. Holberg denied that she killed Towery for his money and the drugs, but testified that she took the money thrown at her. The evidence is that high on crack cocaine, Holberg gained the edge in the frenzy of the fight, repeatedly struck Towery, and in her own words, "I lost it." To challenge Holberg's account of self-defense and to advance its robbery theory, the prosecution called Kirkpatrick to the stand. Kirkpatrick testified that Holberg admitted to killing Towery, that she stabbed him with a fork, okay, that she had stuck the lamp down Towery's throat because she got tired of hearing him make gurgling and gagging noises, that she initiated the altercation with Towery in order to get money for a fix that Holberg thought the fountain of blood was just pretty, fun and amazing, and that Holberg would do it all over again for more drugs, a remarkable draw upon the autopsy report as read by the prosecution. This is trigger warning, trigger warning. This is pretty terrible, guys. It's pretty terrible. Holberg, however, testified that she never spoke with Kirkpatrick while in jail, that Towery initiated the violent struggle, and that instead of the euphoria Kirkpatrick depicted, she was afraid, terrified, and could not breathe throughout her violent struggle with Mr. Towery. Melissa Wiseman, a cellmate of Holberg and Kirkpatrick at the Randall County Jail, also testified and supported Holberg's assertions, stating that the cellmates were all in the cell at the same time, and that she did not ever hear a conversation between Mr. Holberg and Mrs. Holberg and Mrs. Kirkpatrick, where Mrs. Holberg was describing committing acts against Mr. Towery. Besides Holberg's own description of the events, Kirkpatrick provided the sole testimony of what happened inside Towery's apartment. The prosecution pointed to additional circumstantial evidence, such as the amount of money on Holberg's person after exiting Towery's apartment, prescription missing from Towery's apartment, and the rifled contents of Towery's wallet, to argue Holberg killed Towery while robbing him. The jury convicted her of murder and sentenced her to death. Okay. Holberg, her counsel, and hence the Amarillo jury, had no knowledge that Kirkpatrick was a confidential informant for Corporal Stallings. That in the months leading up to Holberg's alleged confession, Kirkpatrick had almost daily contact with Corporal Stallings, who paid her $100 for each drug buy. Then he paid her thousands of dollars to make drug buys, and that Kirkpatrick helped the Amarillo Police Department write approximately 40 search warrants and secure multiple convictions. Indeed, during a trial of Kirkpatrick's, after Holberg was sentenced to death, Robert Love, one of the prosecutors in Holberg's case, repeatedly referred to Kirkpatrick as a confidential informant. And Corporal Stallings admitted that Kirkpatrick helped the department on many, many things before testing against Holberg. Kirkpatrick wrote to the judge, handling her burglary charge, touting her informant work as a reason why the judge should give her probation. At the time of Holberg's trial, the state knew about Kirkpatrick's confidential informant work for the Amarillo police, but presented her to the Amarillo jury as a disinterested individual who wanted to do the right thing and was attempting to be as truthful and complete as she could be. The state did not disclose Kirkpatrick's work as a paid informant until after Holberg was sentenced to death. Holberg's counsel cross-examination of Kirkpatrick spanned only 6 pages of the trial transcript, a reality that speaks to the volumes, because there is volumes and volumes of transcript in this case. As in most death penalty cases, Then, during Holberg's post-conviction state habeas proceedings, Kirkpatrick, in 2011's deposition, recanted her testimony at Holberg's trial, asserting that the state used her pending burglary charges as leverage to ensure her testimony at Holberg's trial. Specifically, Kirkpatrick stated that the then district attorney, James Farron, coached her statement at Holberg's trial, and that Farron both threatened to send Kirkpatrick to jail if she did not give him what he wanted, but also offered her a deal if she cooperated. Kirkpatrick also stated that Holberg seemed remorseful and sad about Towery's death, and that Holberg never used the descriptions fountain, pretty, fun, or amazing when discussing this murder. This narrative, which the jury did not hear, raises Kirkpatrick's credibility. Yes, it does. Either her testimony at trial was supplied by the state, or her recantation was a lie. Against this context, the state's intentional non-disclosure of Kirkpatrick's informant status strikes at the heart of the jury's conviction, and most assertedly, its sentence to death. Consistent with AEDPA, Holberg has challenged her conviction and sentence on multiple grounds in proper state and federal forums. After each denied all of Holberg's claims, we granted a certificate of appealability for two of her claims. First, Holberg asserts that the state suppressed evidence that the most critical witness, Kirkpatrick, worked as a paid informant for law enforcement. She is entitled to relief under Brady versus Maryland and related cases. Second, Holberg argues that her trial counsel failed to investigate and present compelling mitigation evidence in the sentencing phase, entitling her to relief under Strickland versus Washington and its progeny. Finding the Brady claim dispositive, we focus on that issue. Now, in affirming Holberg's conviction on direct appeal, the Texas Court of Criminal Appeals recognized that Kirkpatrick was a key prosecution witness, adopting crucial parts of her testimony in its final order, incorporating the state trial judge's determination. However, the Texas Court of Criminal Appeals denied Holberg's Brady claim, finding that Holberg's allegations regarding Kirkpatrick have no merit. Specifically, the state court emphasized the absence of a plea agreement between the state and Holberg. The prosecutor's testimony that Kirkpatrick did not ask for any kind of a deal, for testifying against Holberg that the state did not refer to Kirkpatrick's testimony in its closing arguments at the punishments phase, and Kirkpatrick's testimony that she did not testify at Holberg's trial thinking that it would help her get a better deal on her own charges. Now, we know that's not true. We know that she did lie. In federal habeas proceedings, the Able District Court concluded that although Holberg had properly exhausted her Brady claim as required by AEDPA, she was not entitled to relief. Specifically, the federal district court found that Holberg's Brady claim would have backfired because the trial counsel knew there was no deal between Kirkpatrick and the prosecution at the time of Kirkpatrick's testimony, and that disclosing Kirkpatrick's confidential informant status would have merely allowed the prosecution to further bolster Kirkpatrick's testimony. The prosecution would have emphasized to the jury that Kirkpatrick was only testifying for altruistic reasons, not pursuant to some deal, and that she was a trusted informant with a reputation in the community for truth. Ultimately, the district court held that under Brady, the state habeas court could reasonably conclude that Holberg failed to demonstrate that Kirkpatrick's informant status was favorable or material in a way that would undermine the confidences of the verdict. On appeal, Holberg reasserts her constitutional challenge, arguing that the state violated her due process rights under Brady when it failed to disclose Kirkpatrick's status as a confidential informant. Okay. And then there's the other part. Number 3. After exhausting their claims in state court, prisoners turning to federal court must overcome the relitigation bar of AEDPA. That is, the court must show AEDPA deference. Under this congressionally mandated standard, we defer to the state court's decision unless, number 1, was contrary to our, and number 2, involved an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States. While the first exception, the contrary to prong, is narrower in its reach, the second exception is still quite demanding. Under the second exception, it's not enough that a federal court disagreed with the state court as a matter of independent judgment. Rather, the second exception asks whether the state's court determination was unreasonable beyond any possibility of a fair-minded disagreement. Assuming a prisoner overcomes AEDPA's Relitigation bar. Successful Brady violations provide grounds for habeas relief. In Brady, the Supreme Court held that the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to the punishment, irrespective of the good faith or bad faith of the prosecution. The purpose of the Brady and its progeny is to ensure that criminal trials are fair and that miscarriage of justice does not occur. Placing the burden on prosecution to disclose information illustrates the special role played by the American prosecutors in the search for truth in criminal trials. A prosecutor must disclose evidence to the defense because it's in the interest. It's not that it shall win a case, but that justice shall be done. To succeed on a Brady claim, then a petitioner must establish number one, favorable evidence, and number two, was suppressed and was relevant, and number three, that the suppression was material or prejudicial to their case. As the state rightfully concedes, the evidence of Kirkpatrick's status as a confidential informant was suppressed. We will consider only whether this evidence was favorable and material to Holberg's case. Favorable evidence is evidence tending to strengthen the defense or the character of a piece of evidence as favorable will often turn the context of the uh, will often turn on the context of the existing or potential evidentiary record. Over a decade before Holberg's trial, the Supreme Court held the United States versus Badley that favorable evidence includes impeachment evidence because impeachment evidence is evidence favorable to the accused. For many years now, it has been well-established federal law that impeachment evidence falls within the Brady rule. The Supreme Court has emphatically disavowed any difference between exculpatory and impeachment evidence for Brady purposes. As to the materiality element, evidence is material only if there is a reasonable probability that had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. The touchstone of the materiality analysis is a reasonable probability of a different result, such that the government's evidentiary suppression undermines confidence in the outcome of the trial. The Brady materiality analysis is not considered in light of the probability of acquittal, and instead simply asks whether there is a reasonable probability that the resulting proceedings would have been different. Materiality is not sufficiency of evidence test. Now, here's the thing about this. I think it might have made a difference in this case because there was no witness to the crime. The only thing they could use against her was the fact that the cellmate said blah blah blah. So to me, it could have made a difference and it should have been disclosed. But we'll keep reading. Hang on. Holberg argues that Kirkpatrick's status as a confidential informant for the city of Amarillo police is favorable evidence, a reality that the state properly concedes. Counsel for the state, when questioned about whether Kirkpatrick's status as a confidential informant would have been favorable biased evidence to cross-examine. Oh crap, I can't talk to you. Sorry guys. Hang on, let me make a note here. I have to call him. I need to call this person back. Just a second. I'm so sorry, guys. Let me tell him that I will call him back. I'm so sorry. Yeah. All right, there we go. Sorry about that. Okay, let's keep going. So, when questioned about whether Kirkpatrick's status as a confidential informant would have been favorable biased evidence to cross-examine and impeach Kirkpatrick, said that in fairness, Your Honor, I think it would have been favorable. We agree. See, I thought it would have been favorable too. This evidence would have strengthened Holberg's defense at a trial. Specifically, Holberg's counsel could have pointed to a trove of suppressed evidence to impeach Kirkpatrick. Holberg's counsel could have introduced the evidence of Kirkpatrick's work for the city of Amarillo, including approximately 40 search warrants and multiple convictions secured, the thousands of dollars she received as cash payments for her information, her daily communications with the Amarillo Police Department during the months leading up to Holberg's alleged confession, and the legal benefits Corporal Stallings secured for Kirkpatrick on the same day that she shared Holberg's alleged confession. which included a dismissal of criminal trespass charges and a release on bond. Instead of the 6-page cross-examination, Holberg's counsel could have effectively cross-examined Kirkpatrick and undermined the state's only testimonial account of the violent encounter. The state emphasizes that Kirkpatrick was a paid informant in unrelated matters because Kirkpatrick was only formally paid cash for her assistance in unrelated cases. The state argues that Holberg's facts are distinct from those considered in the Brady and Banks versus Brittany. But the state's argument has no purchase. For decades, it has been established federal law that impeachment evidence is favorable evidence under the Brady's protections. And as the Supreme Court recently stated, certain principles are fundamental enough that when new factual permutations arise, the necessity to apply to earlier rules will be beyond doubt. Indeed, Kirkpatrick's confidential information status is classic favorable impeachment evidence, and the state court unreasonably applied Brady and its progeny in concluding otherwise. Any reason to support a conclusion that evidence was not favorable to Holberg is contrary to the court's precedents, and therefore an unreasonable application of clearly established federal law. Finally, we consider whether any reasonable theory supported by the state's court's conclusion that withheld evidence was collectively immaterial. After a careful and deferential review of the record and the findings below, we find that the state has disclosed Kirkpatrick's status of a confidential informant. Therefore, it is reasonable probability that the result of Holberg's proceedings would have been different. So yes, they did violate Brady, according to the appeals court. Holberg was convicted and sentenced to death for capital murder in the course of committing or attempting to commit robbery. Kirkpatrick's testimony was critical to the state's case, providing the supporting evidence for the robbery, undercutting Holberg's account of self-defense, and painting her as an unremorseful addict who posed a continued threat to society. In fact, the state represented on direct appeal that Kirkpatrick's testimony was direct evidence, and that alone proved that Holberg committed the murder in order to get Towery's money and to get drugs. Furthermore, Kirkpatrick's testimony was the state's only evidence to assert that Holberg took pleasure in this gruesome act. The details include Holberg's statements to Kirkpatrick that she'd do anything to get her drug money, and that if she had to do it all over again, she would. And that Towery's blood looked real pretty like a fountain, and that Holberg shoved that lamp down Towery's throat to stop his gagging noises. I'm telling you, trigger warning, it is horrific. Despite the defense assertions that the state disavowed such statements as jailhouse talk, the prosecution relied on the talk throughout both the guilt and the punishment phase of the trial. During the guilt phase of Holberg's trial, the lead prosecutor explicitly drew on Kirkpatrick's testimony in his opening statement and used Kirkpatrick's version of the murder to describe the violent struggle and comment on Holberg's mens rea and challenge Holberg's credibility as a witness. Specifically, the prosecutor cited Kirkpatrick's testimony that Holberg used the lamp to stop Towery's noises, and that Holberg was amazed by the fountain of blood, and that Holberg would do anything to get her drug money, and that Holberg had lied to Kirkpatrick about her sexual relationship with Towery. The prosecutor ended his opening by telling the jury that they would hear Towery's noises, not in this courtroom, but in their thoughts and in their sleep and in their dreams, maybe for the rest of their lives. That was bad. He should have not done that. While cross-examining Holberg, the prosecution used Kirkpatrick's testimony to challenge her testimony that she did not plan to use a lamp to kill Towery, and to undercut Holberg's denial that she would do anything to get her drug money. At closing, the prosecution again leveraged Kirkpatrick's testimony to maintain that Holberg admitted to killing Towery for a fix and showed no remorse. And during the state's rebuttal, the prosecution asserted that Kirkpatrick was telling the truth, and that Holberg really did talk to Miss Kirkpatrick, and she did tell her these things. The state continued to rely on Kirkpatrick's testimony during the punishment phase of Holberg's trial. In Texas, capital cases require a bifurcated proceedings, a guilt phase and a penalty phase. If the defendant is found guilty, a separate proceeding before the same jury is held to fix the punishment. During the penalty phase, the jury answered the following 2 questions. Number 1, do you find from the evidence beyond a reasonable doubt that there is a probability that a defendant, Brittany Marlowe Holberg, aka Brittany Marlowe Johnson, would commit criminal acts of violence that would constitute a continuing threat to society? And number 2, taking into consideration all the evidence, including the circumstances of the offense, the defendant's character and background, and the personal moral culpability of the defendant, do you find that there are sufficient mitigating circumstances or circumstance to warrant the sentence of life imprisonment rather than the death sentences imposed. If the jury returns a unanimous finding on the first question and a unanimous negative finding on the second question, then the court shall sentence the defendant to death. If at least one juror disagrees to either question, then the death sentence is precluded. When Holberg's trial was conducted in two phases, the state reoffered all the admitted evidence in the guilt phase at the beginning of the sentencing phase. Kirkpatrick's testimony again, the state's only evidence that Holberg enjoyed the violent encounter, was critical in the jury's unanimous affirmative finding on the first question in the punishment phase of Holberg's trial, whether Holberg would commit criminal acts of violence that would constitute a continued threat to society. So they're relying on this one paid informant who we know lies, right? I think that department should have been looked at. They need to investigate that department. In my opinion, not that my opinion counts, but in my opinion, they should have investigated this. The force of Kirkpatrick's testimony was demonstrated by its use in the hypothetical posed to the state's expert psychiatrist, Dr. Coons. The prosecution referred to Kirkpatrick's statements when it laid the foundation for Dr. Coons stating, and that finally, at some point, while Towery was probably still alive, I want you to assume that an 11.5-inch lampstand, a pole-like object, with a round plate was just jammed down his throat with what the pathologist described as significant force, some 5 inches down his throat. I want you to assume that the defendant, Mrs. Holberg, in some 5 or 6 different versions of what occurred, told at least one person that Towery was making some kind of gagging sound and that she shoved the lamp down his throat to stop the noise. Dr. Coons, in turn, used such statements to conclude that there was a probability that Holberg would commit criminal acts of violence in the future, which could constitute a continuing threat to society, stating that the gratuitous lamp down the throat spoke an intensity and anger and violence, and was unnecessary and was overkill. Relying on the state's hypothetical, Dr. Coons concluded that although there appears to be an easy opportunity to get away, the violence was carried on to a conclusion. The state, in its closing arguments of the punishment phase, emphasized that Dr. Coons' testimony in employing the jury to find that Holberg would continue to commit criminal acts of violence, and the jury ultimately did. Kirkpatrick's testimony was material because the defense counsel was effectively deprived of the opportunity to impeach her during trial. The Supreme Court has recognized that the witnesses who are compensated for their testimony have acute incentive to lie. Despite this incentive, the court has concluded this testimony may be presented to the jury because the jury can weigh a witness's credibility when their status as a paid informant is disclosed. This status is subject to rigorous cross-examination, and the jury receives a clear instruction to be cautious when weighing such testimony. And that's absolutely correct. That is fair. Kirkpatrick's testimony and what Holberg allegedly told her in the jail cell turned on her credibility. Through Kirkpatrick's asserted at the trial that Holberg was the source of her information, the jury was not presented with the possibility that her statements were cultivated by the prosecution. The jury's ability to weigh Kirkpatrick's credibility against the information elicited by the defense counsel was only as effective as the information provided to them. As such, we are persuaded that had Kirkpatrick's informant status been disclosed, defense counsel could have challenged Kirkpatrick's credibility and the true source of her statements, as so to raise a reasonable probability that at least one juror would have struck a different balance. In light of Kirkpatrick's role as a key prosecution witness, one that supplied the state's only testimonial account of the violent encounter and direct evidence of the alleged robbery, there is no sound theory considering the record as a whole to support the conclusion that evidence of Kirkpatrick's suppressed status as a confidential informant did not reasonably affect Holberg's trial. The state court's findings of immateriality is unreasonable application of clearly established Supreme Court law. The federal district court, however, found that suppression of the evidence did not prejudice Holberg because there was no formal deal for this case in place at the time of trial, and Kirkpatrick's impeachment would have only empowered the state to bolster Kirkpatrick as a reliable, confidential informant. This analysis misses the mark on materiality. First, the federal district court's potential bolstering reasoning is dubious in light of the state's own view of Kirkpatrick. In the immediate aftermath of Holberg's trial, the state did not vouch for Kirkpatrick's credibility, but savaged it. Mr. Love, who prosecuted both Holberg and Kirkpatrick, argued that Kirkpatrick's burglary case barely a month after Holberg was sentenced to death So they did try her. Oh, that's bad. They did try her even after she did. Okay, no wonder she recanted. This is why she recanted, I believe. Miss Kirkpatrick has lied throughout her entire testimony and, in fact, was caught in a lie before she got up on the witness stand today until I pointed it out to her and her attorney that she had a previous felony conviction. Second, and more importantly, materially simply requires showing there is reasonable probability that the result of Holberg's proceedings would have been different. We ask only whether is it reasonably probable that denying defense counsel's undisputed fact that Kirkpatrick was a paid informant and that the state held the further sentence of burglary charge over her head for trial would have impacted the trial outcome. The state also points to Holberg's own damaging testimony to argue that withholding Kirkpatrick's status as a confidential informant was not prejudicial. The state's observation, alas, fails to account for the real possibility that Holberg may have never testified were it not for Kirkpatrick's testimony. More importantly, as the circuit has previously held, even if the state court could have concluded that the jury could still have convicted Holberg based on her own testimony, that too would be an unreasonable application of the Supreme Court law. Materiality is not sufficiency of evidence. Again, Brady is not a sufficiency of evidence analysis. It instead requires asking whether there is reasonable probability that the outcome would have been different. We find that the reasonable probable that the defense counsel's impeachment of Kirkpatrick during the trial would have undermined the jury's confidence in the state's argument. Had the suppressed information been disclosed, defense counsel could have mounted a more fulsome argument that the jury's to discredit Kirkpatrick's testimony. With all due respect, our able colleague stepped past the salient issues in his dissent. The prosecution's reliance upon the credibility of Kirkpatrick's testimony while withholding from the defense counsel that she was a paid informant placed in Holberg's cell on her arrest, taking only 2 days to report Holberg's confession to the killing and embellishing details of Holberg's delight in the fountain of blood and her blows produced. This dissent argues that the state's failure to disclose had no salience as the state produced a mountain of evidence of the brutality of the killing in which Kirkpatrick was not the source. With respect to the prosecution, thought otherwise, electing to disobey a fundamental tenet criminal prosecution. But the prosecution's failure to disclose was not an oversight. It was rather a tactical decision in service of its reliance upon the credibility of Kirkpatrick throughout the trial. Both Brady and Gigolo respond to the real-world effects of handicapping counsels and preparing for defense in the case. Did Holberg tell Kirkpatrick that she enjoyed the fountain of blood, or was Kirkpatrick simply enhancing her bargaining power in her own then ongoing negotiations of her pending charges of burglary? It bears emphasis that Kirkpatrick did not create her testimony on her own. Unbeknownst to the jury, Kirkpatrick's statements were compensated by the state and intentionally withheld information. The prosecution went to great lengths to obtain Kirkpatrick's testimony. 6 months had passed between the state's initial investigation into Towery's death and Kirkpatrick's involvement in this case. The prosecution made multiple attempts to secure testimony against Holberg from her cellmates, offering them deals in exchange for false statements to no avail. But within two days of placing Kirkpatrick in Holberg's cell, the state received Holberg's alleged admission. The state compensated Kirkpatrick by dismissing her criminal trespass charge and releasing her on a bond. Critically, however, the state held that Kirkpatrick's felony burglary charge over her head until after she had testified against Holberg. The dissent, and a footnote dismisses Kirkpatrick's 2011 recantation, stating the state's habeas court ruled that Kirkpatrick's recantation was not credible. With a defiance to the state court, its determination of Kirkpatrick's veracity in the distinct environment of a separate proceedings is at best further evidence that Kirkpatrick's testimony turned on its benefits to herself. In the words of the federal district court, Kirkpatrick is a liar. It is undisputed that Kirkpatrick cut deals with the state in exchange for protection from prosecution, and that the state relied upon this testimony. Kirkpatrick later recanted to bolster its case. Defense counsel, however, was never given the opportunity to cross-examine Kirkpatrick effectively and to develop a relationship between Kirkpatrick and the state. The dissent also argues that Kirkpatrick's testimony was immaterial as to Holberg's sentencing, asserting that her testimony played virtually no role in the punishment phase. The dissent analysis of the trial transcript, however, disregards the mechanics of bifurcated trial and capital punishment. The dissent cannot take a solid view of the punishment phase, especially as the state reintroduced all its guilt innocence phase evidence, including Kirkpatrick's testimony, before the very same jury. Furthermore, common experience supported by empirical studies demonstrates that evidence and arguments presented during the guilt phase of a capital trial will often have a significant effect on the jurors. As the state's only testimonial account of the violent encounter, Kirkpatrick's testimony presented a gripping story. Though Kirkpatrick testified only in the guilt phase, the narrative force of her words had lasting impacts on the jury, as was Kirkpatrick alone, who stated that Holberg relished in the violent act against Towery. The prosecution recognized this, telling the jury that they would remember Kirkpatrick's statements in their thoughts, their sleep, and their dreams, maybe for the rest of their lives. And that was overkill, and I don't think he should have made those statements. Our colleague is in dissent underestimates the power of an advocate armed with the evidence of her illegally withheld and its impact on the trial. The fatality is this driving force of the Brady Doctrine itself. We highlight here Glossop versus Oklahoma. Now we have a live on Glossop versus Oklahoma. We just did this one a few weeks ago. The recent decisions of the Supreme Court reversing and remanding the Oklahoma Court of Criminal Appeals and the judgment and ordering a new trial for the defendant Richard Glossop. The court found that the jury's credibility assessment of the prosecution's star witness necessarily determinative that the prosecution's Napoo versus Illinois was a violation of materials, even though the jury was aware the witness in question was untrustworthy. Here, the state succeeded, blocking evidence undermining Kirkpatrick's credibility. Given the prosecution knowledge and the non-disclosure of Kirkpatrick's government informant status, the deal it struck with her, including a ticket to avoid jail, the prosecution had to know there was at best a high risk of presenting false testimony. We do not conflate Brady and Napoo, but only know that this recent ruling reinforces the ultimate decisions in capital cases that lie with the jury. Practices that take the power from the jury to the prosecution are forbidden. Brady and Napoo hold hands in their efforts to protect the jury in their decision making and to preserve fundamentals of a fair trial. The critical question here is where there's reasonable probability that had the evidence been disclosed to the defense, the result of the proceedings would have been different. And because Holberg's conviction required a unanimous jury recommendation, materiality here requires only a reasonable probability that at least one juror would have decided differently. Looking at these facts through these lenses of a jury who was deprived of this information, we find that at least one juror would have done so. There is a reason that Brittany Merle Holberg has been on death row for over 27 years. The state denied her right to due process by keeping from her the jury evidence favorable to the defendant, and this suppression prejudiced her case. Okay, by the metrics of the AEDPA, a fair-minded jurist could not disagree that the state's court's denial of relief involved an unreasonable application of clearly established Supreme Court law. For these reasons, we reverse and vacate Holberg's conviction and remand the case to the district court for further proceedings consistent with this opinion. So there's the opinion right there. Now, and this is just, we're not going to read all this. We're going to go watch. Let me get down here to the bottom of this because they did overturn it. Now let's go back and watch her. Hang on, I'm going to go pull up the. Hang on a second. The oral arguments because the oral. Hey Cinderella, good to see you. Watching and cleaning, listening and cleaning. Yeah, this is one of those cases where it's good to just listen to it while you're doing other things because there's not a lot to see. Now I am going to show the oral arguments for this case, but I think it's interesting that in this case they actually state the same case that we just talked about, which is Glossop versus the state of Oklahoma, because they also had Brady violations in that case, and that's very important. So let's go pull up her Court of Appeals, the oral argument, which is always fun to watch. I love watching those. So we get rid of this right here. Now let's go see oral arguments. Okay. I just want to do a short live about this today because I want to know how you sit on death row for 27 years, and now we know. Okay. Brittany. Holberg. I was going to say Harlow. Silly. Okay. Let's pull this up. Got to go find the actual. Oh, I forgot to put a word in there. Let me add this to it so we can pull this up. Okay. Okay. No, I want the oral arguments there, please. I know it's there because I just found it yesterday. Nope, I don't want to see that. Hang on just a second. It's going to take me just a minute to get this oral argument pulled up. Okay, let me do it this way. All right. Back up. Hang on. Find oral. Okay. Which is Holberg versus State. Okay. Here we go. Read more. It's right here. Okay. I think I found it right here now. Here we go. Holberg. Okay. Wait a minute. Come on. Oral arguments. Search oral arguments. Brittany Holberg. I got to spell her name right, guys. I know. I know it's here. It's Guerrero, I believe. Okay, versus Guerrero. Hang on. Oh, Jesus. Where is this? Okay, now look. Select jurisdictions. Fifth. Oh, I got to find the Fifth Circuit, dumbass. Okay, here we go. Fifth Circuit. Here we go. Apply. Okay. And let's go find the list. Okay. I'm sorry, it's just taking me a minute to get this pulled up. It says check your spelling, blah blah blah. Okay, case name, which is right here, Holberg. Why is it not pulling up? Okay, just a minute. All right, let me go find this right quick. It's giving me a hard time. It's like I don't know what you're talking about, but I know it's. Maybe if I just pull it right from here, I'll get this right here. Versus Eric Guerrero. Okay, copy, and this is from copy text. July of 2025, but oh, it was January of 26. Okay, January of 26. They did the oral arguments. They sure did. Okay, here we go. So it's January. We go back all the way to January. Okay, January. Before May. Okay. Hang on. May the 1st. All right. Judge docket number. Oh, case name. There we go. Paste. Search. Okay. Oh my God, I know it's here. I just saw it. Ugh, just a minute. There's that. Okay. Oh, girl, I don't know why this is being so why it's being so difficult to find it today. I had it yesterday, you know. Oral arguments. Let's see. Boy, oh boy. Let me get the case number. 21. Get right here. Maybe this will help. Copy. All right, let's get right here. Find the oral argument. Put the case number in. Court listener. No. Okay. And put the case number in right here. Okay. Paste. Sorry, I said a bad word. Said a bad word. Didn't mean to say a bad word. All right. Let's go look at it over here. Let me close some of these. I got too many things open, and it's making my computer go slow and stupid. So here we go. All right, now Put this number in here. Here we go. Paste. Okay, backspace. Here we go. All right, this should get it right here. Enter. There's that. Okay, here we go. We got to go back to January. Let's want to. Okay, we put January. It's 01. Okay, sorry guys. 012026. And 05/01/2026. I don't know the exact date. If I did, I would go ahead and put it in there, but that contains Holberg. Here we go. Come on. Let's put this docket number in there. I don't know why this is being so difficult. I really don't. It should have just went right to it. Search. Okay. Holberg. I know I'm spelling it right. Oh boy. Oh my God, please. Oral arguments. There we go. Recordings. Okay, oral argument recordings. So let's go back to January. Here we go. All right. Just a second. It's thinking about it, doing the circling. Come on, come on. Okay, now we can go backwards. Oh, that's too far. 2. Okay. Oh, are they in the wrong order? They are in the wrong order. Okay. 2009, 2020. Okay. 2022. Here we go. Boy, these are hard to look up this way, aren't they? All right, let's see. Come on, open up. 21. Well, this is crazy. They had this argument in January of 2020 of 26. I want to find this. Okay. Oh my. See, there's the court listener right there. It's showing it right there. Come on. Okay. Here we go. Now, I think it's right down here. Yay. Okay. Ooh, this is because she's been there 27 years, there's a lot of different things to go through here. I got to get all the way down to the bottom of the page here. Let's see. Okay, that happened in 2025. Next. Okay. There's dockets. Partners. So was appealed the first time in 2025. I don't want to be on pacer. I want to find the dang oral arguments. Hang on a second. Okay. Ooh, there's a bunch of them they did on that day. Hang on, guys. Damn, I don't know why this is so hard to find. It's about driving me insane. Okay, let's see. There's 200. Oh wow, $10,000. Oh boy, that's a lot. Let's see if we can find it here. Paste that right there and see if it'll go to it. There we go. I guess we're gonna have to. Okay, so we're having an issue here. It's not wanting to pull it back up. I don't know why, because I do know they had the oral arguments in January, and I need to find them. Sorry about that. Let me see if I can find it over on this one. We'll get this one. Find oral arguments. Okay, for Brittany Holberg, January 2026. Here we go. See if we can get it to find it this way. It's thinking about it. They did have oral arguments. Okay, we'll show it to me. Where to find it? Okay. Directly linked to the audio video file to search you. Okay, Go to the archives. So I'm trying to go to the archives. Okay. Okay, let me tell you. Take me to the archives. All right, here we go. Hurry, 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 hurry. What? You can't? Okay, well, it says it can't take me there. We'll have to do it this way. All right. Okay, what is it saying? What is it saying right here? It can't take me there, but it says it was on January the 21st. Holberg, January 21st. Okay. Okay, now I want to see the actual arguments. Download the MP3. Here we go. All right, now let's share our screen. We finally got it. Damn. I don't know why everything has to be so difficult sometimes over here. Okay, here we go. Share our screen. All right, get ready. Here we go.
170010 Brittany Marlowe Holberg.
Okay,
versus
apparently
Eric
it's just the
Guerrero
audio, but
et
that's
al.
okay.
We'll hear first from Mr. Abernathy. I'm sorry, Abernathy. Is it Nappy? Nappy. I apologize that I said Nappy. Thank you.
Good morning, may it please the court, David Abernathy for the appellant Brittany Holberg. The panel that first heard this case granted relief to Holberg based on her Brady claim, which was based on suppression of critical impeachment evidence about Vicki Kirkpatrick. The Texas Court of Criminal Appeals found Ms. Kirkpatrick was a key prosecution witness in this case. She claimed that Holberg admitted in jail when they were together that Holberg, took money by force, robbed Mr. Towery, enjoyed killing Mr. Towery, felt no remorse, and would willingly kill again in the same circumstances. The prosecution never disclosed, and so the jury never heard, that Kirkpatrick was paid thousands of dollars as a paid police informant by the same department that procured her testimony against Holberg, or that those police knew that Kirkpatrick depended on their informant payments to feed her own drug habit, or that they bonded her out of jail and got a charge against her dismissed immediately after she gave a statement, or that Kirkpatrick, lied to Holberg's jury, told the jury she testified only to be truthful and do the right thing, when in fact she was writing to the judge in her own felony case, asking for probation as a reward for testifying against Holberg. The panel majority opinion and dissent accepted that this evidence was suppressed and would be helpful to Holberg, and the state didn't argue otherwise. But the majority and dissent parted company on whether the evidence was material either to guilt or sentence. It was to both. Kirkpatrick's testimony contradicted Holberg's claim of self-defense, but it also went directly to the robbery element required for capital murder. The state points in its brief to a variety of circumstantial evidence as supportive of robbery, but there's a great deal of other evidence that raises questions about that proof and points to reasonable doubt. We briefed that evidence. The state's brief largely ignores it. Perhaps most importantly, Kirkpatrick's testimony was the only testimony that went directly to Holberg's intent and the time when she formed intent. The prosecution had to prove beyond a reasonable doubt that Holberg formed an intent to steal from Towery before or during the commission of the homicide. And after the fact decision to steal would not suffice. That's not robbery, and therefore it's not capital murder. All of the other evidence presented for robbery that's outlined in the state's brief is equally consistent with a conclusion that Holberg and Towery had an argument that escalated into a violent struggle, that Holberg killed Towery, and whether or not it was self-defense or justified, that she decided after the fact that she was preparing to leave to take property. And that makes Kirkpatrick material indeed critical to capital murder. Even more so on sentence. She testified in the guilt-innocent phase, but that testimony was reintroduced on sentence, and a great deal of it went to the sentence and not to guilt. For example, the prosecutor's opening ended with a dramatic flourish based on Kirkpatrick's testimony, who claimed Holberg admitted she shoved a piece of a lamp into Towery's throat because she wanted to silence the gagging noises he was making as he was dying. And the prosecutor finished by telling the jury, finally, the lamp to stop the gagging noises. I suspect you will hear the gagging noises not in this courtroom, but in your thoughts, your sleep, and your dreams, maybe for the rest of your lives. In the penalty phase, the prosecutor went back to this. His expert went to this, emphasized what he called the gratuitous use of the lamp, and in closing, the prosecutor told the jury this scared both the expert and the DA. The jury heard Holberg present herself in Kirkpatrick's telling as dangerous, sadistic, and utterly without remorse, and that unquestionably affected the sentencing decision in this case. It's confession evidence which has unique power. Kirkpatrick was untouched by any effective impeachment. The suppressed evidence would have destroyed her credibility, and the jury took 11 hours to reach a death sentence here when a different decision by one juror would have changed the outcome. Proceed a little on materiality, obviously ready for questions by the court.
Counsel, I have a question about page 31 of your red brief. It says, the state habeas, this is quoting your brief. The state habeas court ruled Holberg was not entitled to relief because A, the prosecutor complied with Brady by opening his file to defendant, B, evidence is not suppressed if defendant already has it, and C, relief is available only if suppressed information is admissible. Where in the state habeas decision did the state habeas court say that?
That's in the conclusions of law that are stated in the original state habeas ruling.
I'm looking at page 9763, which is your citation for the proposition, and I'm looking at paragraphs 1 and 2, which is what you cited for the proposition. I see nothing to even remotely come close to supporting what you said. So where does the state habeas court say A, B, or C?
Well, obviously we read the decision differently, Your Honor, because
can you show it to me? Can you read it to me?
I don't have that page right in front of me, but you're referring to the page that we cited. The state court made a variety of holdings, or made a variety of findings of facts, some relating to Kirkpatrick, a variety to other things, and then in the conclusions of law addressed the Brady claim, all of the Brady claims together, and explained in its conclusions that it concluded Kirkpatrick, or that Holberg rather, had not established an entitlement to relief for the Brady claim, and it laid out those reasons.
Literally the entire analysis, the entire holding of the case, correct me if I'm wrong, I'm just reading it to you. Holberg has failed to show that the state violated its obligations under Brady versus Maryland. That's 9764, paragraph 3. Where does the state habeas court say any of the things that you attributed to it? I mean, you said in a brief that you filed in our court, the state habeas court ruled Holberg was not entitled to relief for A, B, and C.
We can't hear you over here.
Oh, I'm sorry. Is this not on?
Speak into the mic.
You said that the state habeas court made 3 holdings, A, B, and C. I'm asking you where the state habeas court made them.
Well, I don't want to belabor the point, Your Honor.
Okay.
Obviously, you disagree on how we're reading the state habeas court's decision, but the court laid out findings and then specifically addressed the Brady claim and set forth 3 reasons and stated that I should be clear, that section of the decision doesn't specifically refer to Kirkpatrick. It also doesn't specifically refer to other aspects of the Brady claim that were presented to that court. It addressed the Brady claim all in a single section. And as we read that decision, this is the state court explaining the basis for its decision to reject the Brady claim.
And if I'm understanding the point, you're saying that because the state habeas court never mentions, because Kirkpatrick, if I'm understanding it, you filed an 8-part habeas claim, or 8-part Brady claim. So this is ground for relief 34 of 35 in the state habeas application. There's 8 subparts to it. Becky Bates, John Sneed, Katina Dixon. Part 4 is Kirkpatrick, then Spear, Norrell, Frazier, and Burnett. And because the state habeas court doesn't discuss each of them individually, there is no holding under which we would apply AEDPA's realitigation bar. Is that the argument?
No, our argument, with which the state disagrees, obviously, our argument is that the state court decision sets forth the reasons for denying the Brady claim as applicable to all the aspects of the Brady claim. The state takes the view that that section, although it doesn't specifically exclude the Kirkpatrick claim, is intended to not apply to the Kirkpatrick claim. We disagree with that for the reasons stated in our brief, but I would add that if in fact the state habeas court gave reasons for denying the Brady claim, but somehow did not intend them to apply to Kirkpatrick, then this would be a situation in which the Brady claim relating to Kirkpatrick was properly presented, exhausted in the state court, but not addressed at all, in which case I think, I'm looking for the case, I think it's Johnson v. Williams, would justify de novo review.
Is it de novo review as to all 8 parts of the Brady claim?
I don't know that that's necessarily the case, Your Honor, but we have a certificate only to appeal the claim relating to Kirkpatrick. So whether or not, whatever the standard would be for the other aspects of the Brady claim, they're not appealed here, and we can't appeal them here. So.
Well, of course, we could grant a COA at any time, and we could obviously expand the COA. So I'm asking you if your theory of de novo review applies to all 8 subparts of ground 34 of 35 in the state habeas application.
No, Your Honor, what I was trying to suggest is that if the state habeas court didn't address them, even though properly preserved, de novo relief would be appropriate. But that ultimately, we're not arguing that the state habeas court didn't address the claim. We're arguing they addressed the claim and they set forth the reasons there in the decision, and those are the reasons that apply to Kirkpatrick. We have argued that de novo review should apply to the materiality element of the Brady claim as to Kirkpatrick because it wasn't addressed in the state habeas court's reasons. But I would add to that, ultimately, we don't believe that whether it's de novo review or it's review under the standard in 2254, that doesn't ultimately govern the outcome.
Can you address the standard of under 2254 D1 about what makes the state court's application of Brady objectively unreasonable as opposed to a close call? Can you address that and what your best case is for that? Assuming arguendo that it does apply and that it was addressed under materiality.
Right, Your Honor. The state habeas court referred to an open file policy, but there's nothing in the record that indicates that the suppressed impeachment information was in any open file that the prosecution provided to Holberg's lawyers. The state habeas court also refers to...
was it in the file?
There's nothing in the record, to my knowledge, Your Honor, that would indicate that any of this record, any of this information was in any file that the prosecution furnished to Holberg or her lawyers.
What do you say about the affidavit that Holberg's original trial counsel filed in 2011, where she explained why she did not cross-examine Kirkpatrick more diligently?
Well, several things, Your Honor.
She says she knew about Kirkpatrick being a paid informant, correct?
That's the state's argument. That's not what the record shows.
That's not what the affidavit says?
No, and I'd like to unpack that a little bit if I could, Your Honor. This argument was not argued below in the state habeas court or in the district court or in the original merits
Well,
briefing.
frankly, the argument about Brady and Kirkpatrick was numbered 33 in your points on appeal or in habeas. So it couldn't have been the most important to you either, but leave that.
So the affidavit that is referred to here was made by trial counsel 13 years after trial. And it addressed at the state court's direction, specific ineffective assistance of counsel issues that had been raised in habeas. In one of those points, and all of the arguments about Kirkpatrick and the impeachment being suppressed were already on the record in habeas and had been reviewed by trial counsel at the time she made this affidavit. So she was aware of all these issues and arguments. What she addressed was an ineffective assistance of counsel issue, arguing that she should have called a reputation witness to testify that Kirkpatrick had a bad reputation for truthfulness. And she made several arguments as to why that wouldn't have made any difference. First being that she was, the community in question was criminals and prostitutes, but also she said that if she had presented that reputation witness, law enforcement might have testified that Kirkpatrick provided helpful information to them in another case. There's absolutely nothing in the affidavit about any information that Kirkpatrick was a paid police informant or any of the other impeaching evidence that we've argued was known to the state but suppressed. Actually, later in the declaration, the same trial counsel talks about another claim that she should have cross-examined Kirkpatrick differently or more aggressively. In that section of the declaration, she doesn't say anything at all about Kirkpatrick providing information to the police as a reason for not cross-examining her.
Mr. Abernathy, I hope you can get to the argument that Texas and the courts have been considering for the last 10 years as to materiality. But just to nail on disclosure, has Texas ever pointed in 10 years in federal habeas to a place in the record showing contemporaneous discovery, disclosure of paid informant status?
There's nothing in the record.
Has any state or federal court in 20 years ever pointed and found that it was disclosed?
No, there's nothing.
Did the district court assume it wasn't disclosed in over 100%, quoting Corporate Stallings, who said himself sworn testimony under oath, no one until today knew Ms. Kirkpatrick had been an assistant to the Amarillo Police Department?
Yes, Your Honor.
If it had been disclosed, would it be constitutionally ineffective assistance of counsel to not use it for cross?
I think it's
Okay, so my questions are on what you've had to litigate for the last 10 years in federal court, which is whether or not this is material. And I have a question factually and I have a question legally. Are you saying when the government uses a paid informant to be their government agent witness and doesn't disclose it, that's always material? Or are you saying in these facts, capital case, defendant own words accusing herself, and not just grisly murder, but actually will do grisly murders again? Which is it? Is it factually always material legally, or is it factually this case?
I'm not arguing that in every case, as a matter of law, a failure to, I'm arguing you have to disclose that your key witness is a paid police informant. Is it material? There might be cases in which it's not material. I do think that depends on the facts. But here you have a situation where there's a violent struggle between two individuals. The defendant is claiming self-defense. It may have been a violent struggle that escalated to homicide where self-defense ultimately wasn't supported, but that's still a very different situation from a sadistic, gratuitous killing, and it's a very different situation from a situation
under Kyles and Strickler, Do we ever say, oh, it's not material because there's sufficient other evidence as a matter of law? Or is your position that yes, we can look at whether there was overwhelming other proof, but here, this, in the minds of the jury, had to have affected whether or not they would return a death verdict?
I think you can look at the facts, and you have to review the whole record. And it's not obviously a matter of whether it had to change the jury's mind, but whether there's a reasonable probability, whether the evidence put the case in a different light, in order to, with respect to the issue, whether it's guilt or sentence. But I want to emphasize with respect to guilt, a jury might have decided other evidence just doesn't get you to self-defense. Maybe they found other evidence gets them to the conclusion that Holberg took something from Towery when she left his apartment. But that still leaves a really critical question, which is, when was the intent formed?
Counsel, so I have a question about the lamp down the throat, and then I have a question about the wad of bills that she had on her after the killing. First, the lamp down the throat. You focused on that. You said it was the climax of the prosecution's presentation to the jury, the lamp down the throat to stop the gurgling. If Kirkpatrick had been impeached and the jury didn't believe her anymore, what's the alternative theory in your mind for how the lamp ended up down the throat?
Well, there was evidence both from the scene, forensic evidence from the scene, and from Holberg's testimony that there was a lengthy, extended, violent struggle. She testified that in the course of that struggle, she used the lamp as a defensive weapon, trying to strike out at Towery. And
so the theory is, in self-defense, she shoved the lamp down his throat.
well, self-defense is only one aspect, Your Honor, because there's also a materiality of sentencing issue here. I think this is more sentencing, but...
Well, I mean, let's stay with the lamp. The autopsy report showed that it was shoved so far down his throat that it nicked his carotid artery. So I'm just struggling with, okay, let's say Kirkpatrick is impeached. I'm on the jury. Okay, now I understand the lamp down the throat was in self-defense. That's the theory?
That's a theory relating to guilt or innocence. Okay. But in terms of sentence, Your Honor, the testimony from Kirkpatrick that's critically important is that Holberg said, I got tired of listening to his gurgling or gagging noises as he's dying, so I shoved the lamp down his throat because I didn't want to listen to them anymore. That involves a level of sadism and cruelty that has, I think, clearly a very direct impact on sentence.
So 57 stab wounds is not sadistic with 3 different implements?
Well, in a 45-minute struggle in which...
Most humans can't imagine being stabbed once, much less nearly 5 dozen times while trying to fight back. I've just, this is just sort of my layman's scared of crime belief.
Well, a jury, Your Honor, I think, obviously they're considering the violence and the number of wounds, but they're also considering the context, the trauma that Holberg experienced, the grounds she had to be in fear. In terms of the sentencing, did she use that? Was it a sadistic? Was it a desire to be cruel or excessive? That's an issue the jury had to consider. And in the context of a situation where this was not a calculated, planned violent attack, she didn't bring a weapon with her. All the weapons that were used, there was a fork, there was a kitchen knife,
scissors.
And all of those things were things that were grabbed in the situation at the scene.
Can I just also ask, I meant to ask you about the robbery. So you said that Kirkpatrick's testimony was also material as to robbery. So if Kirkpatrick's testimony had been impeached, then the jury could have come to a different conclusion on the robbery motive, right, which is an aggravating factor.
Right.
So what I want to ask you about is, I thought that there's testimony in the record from Cody Mayo and his girlfriend, Misty Votaw, that after the killing, Holberg offered them $200 for a ride. She had pulled out a wad of cash. One of the bills was bloodstained. That testimony doesn't have anything to do with Kirkpatrick. So why isn't the testimony about robbery, the evidence so overwhelming that undermining Kirkpatrick on that just doesn't make any difference?
I think, Your Honor, that in terms of materiality to guilt, Kirkpatrick is most clearly material to guilt because of the robbery element requirement that she had to form the intent to take the property by force either before or during that commission of the act. Let's imagine that the jury looked at the bills, looked at all the other evidence of the state's outline and said, I believe she took either money or drugs or both. That doesn't answer the question, did she form the intent to do that after the homicide? That makes her guilty of homicide and guilty of theft, but it's not capital murder. None of the other evidence goes directly to that, but Kirkpatrick does, because she testified that Holberg said to her, I went there to get money, I asked him for money, he wouldn't give it to me, so I took it from him, and while taking it from him, I killed him. That's direct evidence of the robbery element with the mens rea at the appropriate time. But that's the only evidence. The other evidence.
Can we turn, I'm sorry.
Counsel, did Mr. Kirkpatrick testify dressed in a prison outfit, prison uniform? Do you know?
I believe she was in jail clothing, and it did come out in a cross that she had a criminal charge.
She had criminal charges pending, so it would have been readily apparent to everyone in the courthouse that in fact she was testifying and that she would hope to get some benefit later on from her testimony. So as I understand your complaint here, your position is that it's her informant status as to other crimes wherein she cooperated with the district attorney's office. Is that correct?
I know I'm out of time, Kelly.
Yes, please, and then I have a question.
She actually flatly denied when she testified that she had any kind of deal or promise or expected any kind of deal or promise. What's impeaching that wasn't known was the people who took her statement against Holberg, the Amarillo police, were paying her all this money in other cases. Of course, employment by the adverse party is always.
Okay, well, I'm trying to focus on your complaint that she was an informant, paid informant, on other crimes not associated with this. And that is what, as I understand your argument, makes her a biased or a self-interested witness. Do you know if any of the times when she was a paid informant in the past, she had given testimony or other information that proved false?
I don't think there's anything in the record that points to any case where she gave false testimony, but it isn't only the payment. That's part of it. It's also the fact that while she's telling the jury in this case, I don't expect anything, I'm just here to do the right thing, she's writing to her judge saying, I want you to give me probation, among other reasons, because I testified against Holberg.
Mr. Aberneth, you've also briefed a claim about ineffective assistance of counsel. And it's unclear to me what the position is. Is the position that any strategy that's described now, this girl next door strategy, that she wouldn't be threatening in the community, was a post hoc rationalization to justify poor choices of not doing a proper mitigation? Or was it that it was the strategy and we're sticking to it no matter what we find out that's contrary to the strategy that would actually support a much stronger strategy, but we've run out of time? What is the argument on this? It's not, our panel opinions have been vacated and they didn't really address it, but the district court addressed it. It's addressed in the briefs. Can you please tell us what your argument is on this point?
I think the primary argument here, Your Honor, is that the defense counsel made a decision at the outset of the case as to what their strategy was going to be. They refused to vary it even when there were multiple red flags that showed things they should have been pursuing. They made the decision, we're not going to look into anything that's not recent. So they didn't look into any of the early childhood trauma or being born with symptoms of addiction to drugs and all of these other things, and they're outlined in the brief. I don't want to catalog every one of them, but the key point, Your Honor, is that they enabled a situation by refusing to investigate, refusing to look at these other issues, where the prosecution was able to present a false narrative that this woman had a perfectly normal childhood with loving parents. There's a little bit of marijuana use in the house, not a big deal. She had love, everything. They said everything was handled to her on a silver platter. That's so far from the reality that could have been presented.
Okay.
It's really stunning.
And is that reviewed under the deferential AEDPA standard, or is any part of that reviewed de novo?
I believe, Your Honor, that the ineffective performance is subject to 2254 review, but the state, I think, has conceded earlier in the case that prejudice wasn't addressed and would be subject to de novo review.
Okay,
I think
thank
they
you.
acknowledge that.
Thank you. Unless my colleague has a further question, you've saved time for rebuttal. Do you have a question?
I do have a question, a couple of questions. Is an informant's credibility a Brady fact that needs to be known?
Yes, Your Honor. I think that both exculpatory evidence and impeaching evidence about a prosecution witness is subject to Brady, and we're obviously in the latter category here. So it would have to have been disclosed. These facts, we would argue, have to have been disclosed.
Is there any evidence in the record that the police department itself determined that Ms. Kirkpatrick was not a credible witness?
There was this inferential evidence. Kirkpatrick's case was heard, her burglary case, several weeks after Holberg's trial. In that case, the prosecutor really savaged Kirkpatrick's credibility, pointed out to the court that she lied about how many prior felonies she had, that she lied about how many burglaries she was involved in. So certainly shortly after the trial, there's evidence that makes clear that they knew that she had a serious credibility problem.
Did Corporal Stallings testify at her sentencing that because she told him the day he got her out on bond, the day she gave her statement, that she had committed 30 or 40 robberies and only got charged with one, that he decided not to use her anymore after that?
I recall that there was testimony about the commission of the number of burglaries she had been involved in. Candidly, Your Honor, I'm having a hard time recalling specifically whether he testified that was a reason to not use her. Stallings' testimony is in full in the record from the burglary case, and we've cited to some of that, so it would be there, but I don't want to mislead Your Honor that I have a specific recollection of that precise point.
Seeing no other questions, you have saved time for rebuttal. Thank you.
Thank you, Your Honor.
We'll hear from Mr. Cole now.
Thank you, Chief Judge Elrod, and may it please the court. If I can, I'd like to refocus the court on AEDPA, which I think is the most straightforward way to resolve this claim. Of course, our position is that the court should affirm the district court's denial of habeas because the litigation bar forecloses both the Brady and the Strickland claims. Now, on the Brady claim, we have two arguments. The D1 argument with respect to materiality, and then the D2 argument with respect to, excuse me, the D2 argument with respect to suppression. Materiality D1 is probably, frankly, the most straightforward way to resolve this case. And Judge Oldham, you're asking about where do we look for this? And I agree with you in your line of questions in your colloquy that there aren't reasons for this confidential informant period. And so the Richter presumption of marriage adjudication requires us to look at under Harrington and under Sexton, in cases like that, in your opinion, Jimenez, the reasons that could have supported the judgment.
Counsel, before you get to there, it seems to me the question of whether there were reasons could be usefully explored. The 3 paragraphs in the 2012, I guess it is, district court opinion, the state habeas court opinion. First paragraph lays out the basics of Brady. The second paragraph concerns me is, I looked through the findings, 130 some odd pages. Is there anything in there where an open file policy by the prosecutor is identified factually? Is it accepted in this case that there was such a policy? And are there findings to that effect?
I don't believe there are findings as to the open file policy, but that's not one of the reasons that we believe the court.
What I'm asking really is, you have argued that this is first 2 paragraphs are just setting out the rules of the road, and then having fully explored all the ways that you could understand Brady and the ways that you could show a violation. Last paragraph says no violation. What I'm wondering is, it does seem to me to be an incomplete list. The second paragraph primarily. But I don't know if it's at all valid to read, and I know you think it doesn't. I would say it's probably not valid to read this open file policy as a reason, unless there are findings in the order that there was such a policy. And you're saying that's not in the record.
And let me be clear, Judge Southwick, we're not making an argument from the open file policy. We're not saying that's the rule of law that you apply here. The rule of law at issue, the materiality element, we would say, is the bank. But when we're looking to the reasons, what are the reasons? I take that to be an application of law fact. The reason given is this is basically, like in Richter, in our view, an unreasoned state court opinion. And what you do is...
It's not an unreasoned if the court opinion was saying there's an open file policy and the evidence shows this information probably wasn't in the policy. And I'm not explaining myself very well, but I'm trying to get to it. That can't be the reason unless there's evidence that there was an open file policy.
That's right. That's not the reason for the rejection of confidential informant Brady claim. Maybe it's helpful to consider, as Judge Jones was mentioning, and Judge Holberg was mentioning, it's like an 8-part Brady claim. There's all sorts of candidates in the Johnson. And some cases from this court, the Nelson case, indicate that when we're thinking about a Brady claim, it really is evidence specific. And so we're really training our focus, I think the court should, on the confidential informant theory. And when we're asking, are there reasons the state court offered for rejecting the confidential informant theory, we say no, there are no reasons. The open file policy isn't one of them. So I don't think you would look at that when you're sussing out whether there are reasons here. Now, assuming I satisfied you with that, Judge Southwick, I think the reason that we see the only thing is Holberg has failed to show that the state violated its obligations under Brady versus Maryland. When we see that, that's essentially, I would say, akin to a summary denial of the claim. And when you have that, Harrington, Sexton, this court's opinion indicates we look to what reasons could have supported the judgment. So if I can go to the reasons that could have supported the judgment, we have the argument about banks. When we're talking about D1 with respect to materiality, the question is this an unreasonable application of banks, or is it contrary to banks? And we would suggest no on both prongs. I'll talk about the contrary to prong, and this court's decision in Langley indicates that.
One that just factually for me would be helpful, because I like the panel, like the district court quoting corporate stallings, I'm going to assume it wasn't disclosed. So the question is materiality, and your position is it was not material to the defense or to a jury that returns a verdict of death to know that the only accusing witness was actually a government agent being paid. And that witness is the only, correct me if any of these are wrong, that witness is the only witness that tells the jury that Holberg herself accused herself of felony murder. No one else said what the jury had just heard from Holberg with no prior conviction. She takes the stand, capital defendant, takes the stand, says that the man that's been paying her for sex for years initiated the fight and she killed him. She admits that, but she says self-defense. There's no other witness that says, actually, Holberg herself told me in jail that she loved killing him and described in detail the gruesome. In fact, tell me, Kirkpatrick is the only witness that the government put on to say that Holberg said the more she stabbed her, the prettier it was. Kirkpatrick is the only witness that said that Holberg said Her exact words were, "It's fun and it's amazing." And Kirkpatrick is the only witness the jury heard that said that if Holberg had to do it all over again, she would anything to get drugs and money. Fact question, is there any other witness that the government put on that said that the defendant's own words would that she boasted she'd do it again for drugs and money?
So there's a lot packed in there.
No, it's just a fact question. Is there any other witness that the government said that Holberg's own words should convict her and sentence her to death?
The only testimony is Holberg's words and Kirkpatrick, but there's a couple of things in there. If I could start with this, I think the analysis you're asking about is a de novo analysis. Again, this is, you don't get to the sort of de novo question of was this material, was this not, unless Ms. Holberg can clear the litigation bar. And the question.
But you agree the state habeas court said nothing other than Brady denied with a paragraph before saying open files. No state court ever, no federal court, no state court ever has said what you're asking us to say, which is paid witness status for a person who says the defendant convicted herself is actually immaterial.
Well, what I'm asking you to say, Judge Higginson, is that the relitigation bar is the relitigation bar for closest to claim is there's been no unreasonable application of the Supreme Court precedent in Banks, and there's no contrary to precedent in Banks. That's
okay,
all
so, but then it's the same question. Isn't it unreasonable for a court to say it's immaterial to the defense and ultimately the jury that gives the verdict of death? It was immaterial, didn't prejudice the defense. And here are the four places that I would see prejudice. Again, disagree. When Kirkpatrick testifies to all that, only 6 pages across, not a single question that the government might have purchased this testimony, correct?
So we do not think that there's been an application of Supreme Court precedent in which the state habeas court's reasons, again.
But there was no cross at all that this is purchased testimony.
There's no cross.
Okay, and then at closing, the defense barely grasps at anything to impeach Kirkpatrick, starting out saying, well, really, could the blood have been spurting like a fountain? So they had no ability to test that she was testifying because the government was paying.
Again, I want to.
No, I yes or no, and I have 2 other yes or no questions. And then I'm just asking factually. When the government in rebuttal closing gets up and says to the jury, you can believe Kirkpatrick, maybe Holberg isn't a vampire, but you can believe everything Kirkpatrick said because the details are so graphic. No ability to object. And finally, if this had been disclosed, paid government informed status, do you agree that under our jury instructions and under Supreme Court law, this jury would have been told they had to consider paid informant testimony with great caution and care? That's our mandatory instruction.
I think that goes to favorability. We're not really disputing favorability.
No, it goes to materiality. Isn't it true? It would be reversible error if a district court didn't give that instruction that the defense asked for because you had disclosed it. But now you're saying because you didn't disclose it, it's not reversible error that they didn't get it. The Supreme Court's case in Hoffa in 1966, two years before Brady, said the only reason we can trust testimony like this, such an incentive to lie, so compromised, is because Anglo-American safeguards exist, 2 of them, cross-examination and a court instructing the jury, be very careful. Ms. Holberg got neither, but it's not material.
There has been no misapplication of Supreme Court precedent. I think maybe we're talking past each other, and I don't want to. I want to address your question, but really the threshold question here is, has there been a misapplication of Banks? I don't understand what you're saying. Is there a misapplication of Hoffa? I understand what you're saying. Is there a misapplication of Banks? And Banks says, when there is an undisclosed informant who's an informant in unrelated cases, when in the words of this court, it's independent of the relationship, the police's relationship, the police and informant relationship is independent of the things that led to the indictment, then it's not material.
So when you say the words of this court, you mean the Dennis decision?
Yeah, the Dennis decision.
Okay, they're the informant that was, the informant didn't even testify at guilt, correct?
In Dennis?
Yeah.
Yeah.
Okay, the informant, even, there's no evidence that it was a paid informant.
So you might disagree with Dennis, but it's
No, I'm asking you, when you say in the words of this court, it's like Dennis, that witness for the government didn't even testify at the guilt phase, didn't involve saying this defendant's own words accused herself, and the informant wasn't paid. Do you have any case of any appellate court, state or federal, ever upholding a death verdict when the government put on its key witness, but the government withheld that that's actually a government agent who's their agent for hire? Do you have any case that you cited in your brief ever that upholds guilt, death guilt, when the government doesn't turn over that evidence?
Well, I'm not sure it's our burden. Their burden is to show that.
So you don't have a case?
Dennis is the best case I have for you, but.
But it's not a guilt-phase witness, it's not a confession testimony, it's not paid evidence.
And the material distinction, but if you disagree with that, maybe you think that.
No, I don't disagree with that.
But I would submit to you that there's a material distinction between Dennis and Banks. And that's the question here. And I don't think you can say there's an unreasonable application. And maybe you think that, maybe you disagree, but that would have to be an error in the words of the Supreme Court so well founded in the law that you could say no fair-minded jurist.
But that's why I said Hoffa. The Supreme Court has told us what we do with false friend testimony. Government puts the false friend in the jailhouse. We know from Fifth Circuit pattern instructions, then that person elicits the molten core fulminante. Oh, this defendant has convicted herself. And we know if she were retried in state court, Texas would give her 2 separate special instructions had you disclosed this evidence. Number 1, jailhouse instruction. Number 2, covert agent instruction. Texas gives 2. She got none of this.
So maybe I can go to your de novo question directly. I think I've made my point on this.
Yeah, you have.
Let's talk about the materiality standards. So Turner says that you need to look at the entire trial record and you need to look to see whether, to look to whether the withheld evidence in the context of the entire record and determine in the light of that examination whether there's a reasonable probability that had the evidence been disclosed, the results of the proceeding would have been different or would undermine confidence, right, in the verdict. And there's at least sort of 3 levels here. We're talking about self-defense, so let's talk about self-defense. And this court's cases, of course, say when you have strong corroboration by additional evidence for a guilty verdict, it's not material, and it's less likely to be material. And so let's talk about what we have. On self-defense, I think the most powerful testimony was from the medical examiner, and it was a reason that the prosecutor got up and was closing and hit the table 57 times. He's calling attention to, as Judge Young mentioned, the 57 stab wounds. Also very powerful was her testimony of self-defense itself. I mean, she had no explanation for why Mr. Towery had 18 stab wounds in the back. Her explanation for why he had 9 defensive wounds on his hands was that he was holding my hair for most of the time and I was trying to let go. But of course, the testimony was that Mr. Towery was health problems. He was feeble. It took him 45 minutes to walk 4 blocks. That was the testimony the jury heard. And so on self-defense, I think the most powerful testimony was not the 19 pages of Kirkpatrick. It was the testimony about the crime scene investigator, Sergeant Medina. It was the medical examiner, again, went through all that book, and it was her testimony. Now, one of the panel had mentioned that, well, maybe Ms. Kirkpatrick wouldn't have testified. And there's a finding of fact on that from the state habeas court in presumed correct on 2254E1 that actually at the outset, and I'll give you the record site here, it is ROA 98,028. Holberg was insistent from the outset on which she would testify and to present self-defense at the guilt innocence phase of the trial. And after her counsel explained to her the risks of that, however, Holberg consistently and adamantly expressed the desire to testify. So I think the case was quite overwhelming. Additional evidence corroborating Kirkpatrick's testimony. And I know there was a dispute between the panel majority and the dissent about is the sufficiency of the evidence test analysis, is it not? And the way I'm viewing that testimony, essentially, this is sort of additive exercise. You don't remove the Kirkpatrick testimony and say what's left. It's add the impeaching evidence in and say, what do we think the result was? And when you have additional powerful evidence corroborating it, as you have here, you can't say it's material. On future dangerousness, I think my friends on the other side, rightly at page 50 of their brief, said the brutality of the crime was enough to show future dangerousness. But you also have testimony in the record that she may have beaten an elderly man over the head with a cane. She thought she killed him. Now, of course, I won't say there was a dispute about whether she actually killed him there, but the jury heard evidence that she did that. The jury heard from Katina Dixon that she had paid, she wanted to have Kirkpatrick killed. She had testimony about violent tendencies with respect to her ex-husband, cuts, broken nose, all this stuff. So the evidence of future dangerousness was, I would submit to you, again, overwhelming, totally independent of and corroborated by, independent of the Kirkpatrick testimony, which helps corroborate the inquiry into future dangerousness. There was some talk about the robbery, so let me go to that. The evidence, again, was strongly corroborative of robbery. She showed up to Mr. Towery's apartments, very strung out, very high, and she has not very much money. There was some testimony that she said, well, maybe you had $250 or $300, but we know she's just a cab driver, $20 fare, and walks there. And then she goes into the apartment, and she's the one who introduces the suspected of money there. But we know that she's coming down, she's looking for a fix, and we have the strong evidence that she goes into the house without this much money, and she leaves with about the exact amount of money that was missing from the scene. We have the testimony from Mr. Towery's children that he was saving up to buy a car. We have the testimony from Ms. Votow and Mr. Mayo about her spreading out the bills and counting them. There's testimony that there was blood on the bills, and she spent the night buying crack cocaine with his money and partying. So there's evidence that she took that money from him. Strong evidence that corroborates, again.
Is there actually evidence that there's blood on the bills? It seems that there's some sort of dispute between the briefs on that.
There was a dispute in the briefs. I do think the record shows that Mr. Mayo testified that Ms. Votow told him, I think that was the record, correct me if I'm wrong, that there was blood on the bills. I think
Someone told him that, but the bills themselves in the record don't show that. Is that the situation?
I'm not sure what the bills show, Chief Judge Elrod, but I know the testimony was from Mr. Mayo that at least his partner, Ms. Votow, said there was blood on the bills. But
one of the arguments that your friend on the other side made today, and also in the brief, is that the intent to rob could have been formed post the murder. And so do you wish to address that?
I'd be more than happy to, Chief Judge Elrod. I think the evidence is overwhelming and strong that it was not formed in a sort of afterthought to steal from him. Again, she says she's the one who introduced in her testimony that he was throwing money at me, and it was there. And then we have the circumstantial evidence that grant you for sure. Strong circumstantial evidence that she left. She went there with not much money, and she left with a lot. I mean, there's a question in the jury's mind, right? Well, why did she kill him? I mean, her theory was, I was smoking crack, and then he came and got really angry. But her testimony was, I would submit to you, not very believable on this score. And so
on that point, counsel, why did she explain? Why in her view was a lamp, a 11-inch lamp shoved, a lamp post shoved 11 inches down his throat, nicking the carotid artery? What was her explanation for the lamp down the throat?
Judge Duncan, it's a very muddled explanation, but it appears to me that she was engaged in some kind of defensive exercise, and the lamp just sort of happened to go down his throat. Facially implausible. The medical examiner testified that would be essentially a miracle if that happened, and said that it was most likely that she shoved it down his throat, not in some sort of defensive move. Because the precision that you have to do that while engaged in a 45-minute allegedly fight would be amazing.
And I believe the medical examiner also testified that the bleeding associated with the lamp down the throat showed that he was alive when she shoved the lamp down his throat.
Yes.
After the jury heard that testimony, heard about the lamp and all of that, the jury heard that she would do it again for money, according to the informant. Why would that? I'm still unclear. Can you explain why that's not material to the sentencing? The fact that I'm pretty cold-blooded. Not only did I have glee when I did this, but that I would do it again for money. Why isn't that pertinent to or material, not just pertinent?
So a couple of reasons, Chief Judge Elrod. First, the prosecutor actually, I think, sort of sadly, in closing argument, said, this is what Kirkpatrick said but this was puffery, this was jailhouse talk. We don't actually think that she really enjoyed this. This was just trying to make her look bad. So I think he sort of blunted the force of that. But the second thing is that
Counsel, he argued that in closing, but he didn't actually ask Kirkpatrick if she thought Holberg really meant it, though, correct?
No, he didn't ask her that. I mean, it's contextualizing the evidence. But the other argument, the more powerful argument in response to Chief Judge Elrod's question is the other independent evidence of future dangerousness. Again, my friends on the other side in their brief say the brutality of the crime alone, set aside Kirkpatrick, the 58 stabbings, the lamp down the throat, which was, as Judge Duncan said, not explained really at all by Ms. Holberg during her testimony, but also beating over the head of another man who she thought she killed, trying to get another inmate to kill Vicky Kirkpatrick. This is all testimony about future dangerousness in the record that is separate and apart from Kirkpatrick that I think would satisfy a jury that there's plenty of evidence of future dangerousness.
As to whether Kirkpatrick was decisive, both for felony murder, the robbery, and future dangerousness, the DA Farron, that's where he started with Kirkpatrick. The first answer he elicits is Kirkpatrick saying, Holberg told, so the jury's hearing, Holberg said that what happened was the man she had some money on, she wanted him. He was one of her old sugar daddies that had taken care of her for years. And then Farron comes back at the very end and elicits exactly that, both felony status and future dangerousness, getting Kirkpatrick to say that Holberg said that she'd do it all over again. Yes, she would. Question, why? For drugs. Do you remember her saying anything like she'd do it to get drugs or drug money? Yeah, yes, I do.
And again, as I was explaining to Chief Judge Elrod, there's other evidence besides this testimony, which again, and I think Judge Reheard is this point that the district attorney didn't ask her about Kirkpatrick about this, but he contextualizes it in closing for the jury and says, we don't actually think she's so savage as to enjoy it. This was jailhouse talk.
But then in rebuttal closing, the prosecutor comes back and says, we don't believe her. Literally, the word he uses is that Holberg is a vampire. Don't believe that that's what she enjoys, drinking the blood. But do believe her in her details.
Yes.
No, so the prosecutor rebuttal closing, no defense ability to respond. What does he return to? Kirkpatrick. And Kirkpatrick, her details are so good. She did it for drugs and money. She'll do it again. She has no remorse. But that's not material to a jury. There are two questions while they're deliberating or about whether it was robbery.
In the light of the entire trial record, Judge Higgs, I agree. When you isolate it like that, wow, that seems really powerful. But again, in the light of the whole trial record, no, it's not.
But isn't the DA the one who elicited the testimony about Holberg thinking the gushing blood looked pretty? Isn't he the one who asked Kirkpatrick, and did she say anything about the blood looking pretty?
Yes, it came out through Kirkpatrick's testimony, Judge Ramirez.
In response to his specific question. I know it was in her affidavit, but she didn't testify to it. He specifically asked her about those statements, correct?
He did ask her about those statements, and and the response from the defense was actually, well, the fountain of blood seems implausible because there's no arterial bleeding that wasn't shooting everywhere. But separately, again, I think the prosecutor took a lot of the sting out of it when he said, we don't believe she was that callous. We think it was jailhouse talk, which is exaggerated. The reason we should believe her is not because of the explosive nature of those, the descriptive nature of those.
Okay, there's like 20 more minutes of this, and I know it's a lot to listen to, but it's very, very important because when you're talking about Brady violations and a death penalty case, it needs to be relooked at. And there's no reason for somebody to sit on death row for 27 years. This lady's been on death row for 27 years. Okay. So I want to finish listening to this. I might have to come back and actually have the discussion on it later, but I do want to finish listening to it because, it's important. It's very important because we believe that everybody is entitled to a fair trial. And if you have a prosecutor committing a Brady violation, then you don't have a fair trial. So here we go. Let's keep going. Thanks again for coming in. Just hit that like button if you can. Thank you.
descriptions, but the fact that she had details that only Kirkpatrick could have told, that Holberg could have told her.
Well, then why elicit it? If she didn't say that on her own, then why specifically ask her if that's his intent?
Well, there was certainly the record, the affidavit there that was there, so I suppose the defense could have asked her about it. But if I'm not making headway with you on the Kirkpatrick point, I think, again, there's a whole trove of evidence, which I think my friends on the other side say that the brutality of the crime alone, the savage nature of the crime alone is enough to show future dangerousness.
Then why put a paid informant on the stand if you don't need her, if she's the only evidence of intent?
Well, she's certainly, I'm not going to hear you say that she's not helpful, but again, the question is the prosecutor's decisions. The whole trial record, what does that show? When you put it in context, it's not, I don't think it's material.
Well, let's talk about.
I was just saying, when you say it's not the prosecutor's intent, it is the prosecutor's intent. The prosecutor's the only one that knows this is a witness we've been paying in 40 different drug cases. So the prosecutor would, if they don't slightly at the very last say, oh, you might not want to believe her in anything. What they're doing is protecting themselves from a radioactive Brady claim turning into a NAPU claim that the government withholds evidence and then elicits a lie. Of course, they can't say, believe her, because they know they've withheld devastating impeachment.
I don't know that there's any evidence in the record suggesting the prosecutors would intentionally withheld this.
Yeah, counsel, I was going to ask you that. Is there a NAPU claim in this case that the prosecutors, is that even before this court?
It's not, it was rejected on the merits in the state court.
I don't remember any NAPU claim at all in this case. I don't understand why we're talking about it.
I think Judge Jones has a question.
I had a question. If Kirkpatrick hadn't testified, would we be here today about whether she was a future danger?
No.
So the argument of the defense is basically because you put on a jailbird witness who elaborated about the jailhouse confession, that would have caused one and said this person has made other cases in where she may or may not have even testified. And she might even have written to the judge seeking leniency, but which, by the way, she didn't get, that would have made one juror decide she wasn't worthy of the death penalty. That's it.
That seems to be their argument, and as you note, there is whole other independent evidence. Again, there's evidence in the record that Kirkpatrick thought she killed another elderly man by beating him over the head with a cane. I don't want to overstate it. There was evidence from the defense that, well, cause of death, maybe cancer, maybe not. But the evidence was that she beat another individual over the head, another sugar daddy, with a cane, and thought she killed him. There's also the violence with respect to her ex-husband.
Well, given the violence in the record, it seems that I want to ask a couple questions about the Strickland.
Absolutely.
Because it would seem that this strategy to try to have her be a person that could be back in society would be the world's worst strategy. And it also might seem that, and maybe that's not actionable to have the world's worst strategy, but I would like you to opine on that. But also, it seems that the trial was the mitigation phase of the trial, the dangerousness determination, was just, it was not the actual facts at all of what her life was. So what I want to know, at the time that this testimony was proffered, that she just had a normal life until she went boy crazy and she qualified for the Duke tip, but she didn't actually qualify for the Duke tip. But other than that, did the prosecutor and the defense counsel know at the trial that she had been addicted to drugs at birth and that her sibling was stillborn from being addicted? Did the prosecutor and the defense counsel know that at the time this testimony was offered at the mitigation phase, at the dangerousness phase?
I don't know that they knew that. I'm not sure whether or not that is true, that she was addicted to drugs at birth. I think you're going to a Wiggins type question.
I have a whole series. Did the prosecution and the defense counsel know that she was molested at age 4 or 5, and that her mother punished her when she reported the molestation? and then left her again in the molester's care. Did the prosecution and the defense counsel know that?
So Holberg testified to that on the stand. She testified about her, so the jury heard this.
So the jury, did they know that there was something in that or not?
I'm sorry, something?
Did they know that from the other relatives, the extended relatives at the time? The prosecutor
I
and
believe
defense
her
counsel?
stepfather testified that she was gang raped. There's no dispute that it's very sad.
At 4 or 5, that she'd been molested at 4 or 5?
There was some testimony from herself that she was sexually assaulted by babysitter. Yes, I mean, the jury heard from Ms. Holberg's own mouth, I've seen them at a time.
Okay, I'm sorry, I have a couple more.
Yeah,
Did the defense counsel and the prosecution know that the stepfather, who appeared to be just this great stepfather, was repeatedly sexualizing her?
There's no evidence. There's no evidence in the record that that's the case.
So it was not false testimony put on by anybody?
I'm not aware of that. So the district, the state habeas court judge, Chief Judge Elrod, on that point said, we don't find that credible. There's no evidence to support that. That's a factual finding being correct.
What about the friend of her stepfather's that sexually abused her starting at age 12 or 13, but I think 12? Was that presented to the jury? And if not, did the defense counsel and or the prosecutor know that at the time to the contrary?
So I'm not trying to distinguishing between the various sexual assaults that she did testify to, Chief Judge Elrod, but again, you're going, I think, to a Wiggins theory, and if I can, I'd like to tell you what they did, what their investigation was, because it was extensive. And again, this is an EDPA case. This is D1. Was it in this application of Strickland on this point? There's 88 pages of fact findings from the district court, the state habeas court, presumed correct under E1. They hired 2 experienced investigators in the mental health expert. They interviewed many witnesses, family members, acquaintances, prostitutes, drug addicts. One of her counsel walked the streets to go to a crack house to interview people at night. They interviewed Holberg multiple times. They interviewed her stepfather.
They didn't interview her father.
Who was in jail. Yes.
Right, but he was in jail in a very close place.
And he had no real impact on her life. But the question under EDPA, again, is this application of Strickland. Here's what the cases they cite are. They cite, if I can, they cite Porter. What happened in Porter? The attorneys did not even take the first step of interviewing witnesses or requesting records, so the jury heard almost nothing that would humanize the defendant. That's not what happened here. In Rautia, the attorneys failed entirely to examine the defendant's prior conviction file that it knew the prosecutor would use and which contained evidence depicting the defendant's childhood and mental health very differently from anything the defense counsel had heard or seen. They had heard everything. In Wiggins.
So they had heard everything. They had
heard information about her. Did they hear every single possible thing? I suspect not. Did they hear enough to tell them about her childhood? Yes.
And the prosecutor didn't know this stuff? Or because when they said she had a normal family with the drug use is not more than normal, did they know that there was heroin and needles in the house and that they gave their children drugs and that they had them in the meth in the bathtub? Did the prosecutor, when they said at oral argument during the case, did the prosecutor know all these things or not at all?
I mentioned we have evidence about what the prosecutor knew about this.
Did the defense lawyer know?
They certainly knew that she had drugs. I don't know if they knew that
the parents had given her drugs and that this wasn't actually a normal family with a little bit of pot smoking.
Oh, she testified that her parents gave her Valium and marijuana at a young age. So they heard that. Did they hear the full extent of?
And then the last one I have on this is, does Texas, I'm concerned that perhaps that when it's allowed that someone says, oh, the person was fine until they went boy crazy, when they know that they were molested as a 4-year-old and as a 12-year-old.
Oh, God, it's terrible.
That's not going boy crazy. That's a result, perhaps, but we don't know because it wasn't testified on, a result of years of being sexualized as a child. And that's not the same thing as being boy crazy. And if you're having sex at 12 and 13, you're not Lolita in this day and age. You were, it's a sexual abuse of a minor. And so does Texas have viewpoint on this for someone who might be concerned about the mitigation in this
Yeah.
case?
I agree with you, Judge Elrod, but that wasn't the theory of the defense. That was testified to by, I think, a witness. The theory of the defense was that she had a sort of bright future until her Aunt Karen was murdered, which sent her parents into a drug and alcohol-fueled sort of depression. There was testimony again from Holberg herself, reintroduced to punishment, that indicated that her parents were less than stellar, let's say, and that's an understatement. They thought nothing of the sexual assault she reported. They allowed her to have drugs. But again, I want to refocus your questions through EDPA again, because this is EDPA. We have 88 pages of findings of fact. Clear, presumed correct. We have the cases they cite when there was nothing, no investigation done. And that's, again, their sort of Williams claim here. This looks nothing like those cases that they cite. And so it'd be hard for me to see how this court could hold there was a misapplication of Strickland, contrary to or a reasonable application of Strickland, particularly like in Richter, where the Supreme Court in Richter says the more general the standard, the more leeway. I think that whatever else you could say, the defense counsel in this case did a certainly adequate performance into their investigation. And again, there's no prejudice. The state habeas court found that twice.
Thank you very much. Thank you. We have your argument. We appreciate it. Mr. Abernethy, you saved time for rebuttal, sir.
Mr. Abernethy, while you're getting it together, I'm right up here. I'll hit you before you start to get mine in. Just quickly, come back to, we're at the relitigation bar. So just refresh my, we've been through the evidence, but just refresh my memory as to what your specific argument and case is that you're relying on to get you over the edge of relitigation hump. We've heard all about the trial, but you've got a lot in there, but just say it so I'll understand. What specifically is your argument about the relitigation bar in terms of what we have to hold here? What are the specific cases that you're relying on for the in-bank court in light of the bail opinions gone?
Well, Your Honor, I think our fundamental disagreement with the state here and our fundamental argument on this is that banks, the principles that constitute the holdings of Brady.
That's not my question. That's not my question. I want to know, grapple with the EDPA statute and articulate it for me, for us. What is it, the holding you would have this court make with respect to the EDPA standards in light of this case? Don't retell me what the facts in the case are. You follow me?
I hope so. Let me try again. Our argument is that if you apply the EDPA standard in 2254D, it was an unreasonable application of clearly established federal law to hold that.
And the clearly established federal law was?
It's banks primarily that a paid informant.
Paid in this case?
Not paid.
Was it over here? Sorry, paid in this case?
Not paid in this case.
In banks, was the informant paid in which case?
In the same case.
In the same case. And so this is not the same as banks?
Well, that's our fundamental disagreement with the state.
How is it the same? So we've heard a lot about.
Hold on. Don't need
Go ahead with banks.
Don't need co-counsel. You just we'll elaborate on the point. But to what Judge Oldham is asking you, it's sort of the same. And that's narrowing it. So what I'm asking you is not this, the shotgun shot, but the rifle shot, clearly on these facts. That's all I'm asking. We read the briefs and I just want to make sure I understand.
It's an unreasonable application of banks to conclude that because the paid agent of the state, Kirkpatrick, was paid in other cases, that it's not the state isn't obligated to disclose that she was a paid agent of the same police department, that distinction is not material, and it's an unreasonable application of banks to hold. You only have to disclose that this person is your paid agent if you're paying her in the same case. It doesn't go to the fundamental principle underlying banks, which is that paid informant testimony is inherently suspect And when somebody, and that's a fundamental principle of evidence law.
So we held the opposite in Dennis, and so Dennis was wrong.
Dennis was wrong.
Got it. And what is the state of the law in circuits across the country extending banks in the EDPA posture to paid informant status in other cases? Because we heard a lot today, primarily from the bench, about paid this, paid agent, hired testimony. But there's no evidence, as I understand it, that she was paid in this case. And that any of her testimony was purchased in this case. That she may have had other deals in other cases. But we've already held in Dennis that that does not surmount the litigation bar to Judge Stewart's question.
I don't remember the specific case names, I'm sorry, but there are two cases cited in our brief.
Well, you cited the Sixth Circuit Robinson decision, and it
Yeah.
says, first, the facts show Sims assisted authorities as a CI in exchange was paid for his services, regardless of whether the cases were unrelated. Sims had a working relationship with law enforcement, including the agency spearheading the investigation of this case. Robinson was entitled to present such evidence to the jury. Second, the prosecutor's actual knowledge is irrelevant because the individual prosecutor has a duty to learn of any favorable evidence known to others acting on the government's behalf, citing Supreme Court Strickland. Moreover, regardless of whether the prosecution succeeds in meeting the obligation, its responsibility for failing to disclose favorable evidence rising to material level is inescapable, citing Kyle's. So published circuit authority applying Kyle's Strickler says paid informant status to the same police department, same time, is a fundamental Brady violation. Dennis, as we discussed earlier, not a guilt phase witness, not confession evidence, not paid. Is that all correct?
That's all, that's the essence of it. There are two reported cases that we cited where they were not paid in the same case. Your Honor, I'll just make a humble request, given the length of time that sentencing issues were discussed in response to your questions, if I could just have a couple of minutes to address the same questions you discussed with my learned adversary for the state.
You have 1 minute.
So the evidence is a lot more equivocal on future dangerousness. E.R. Williams died of pancreatic cancer, death certificate. The witnesses who said Holberg hit him over the head, they didn't believe her. And that, by the way, could have been the same kind of jailhouse talk that the prosecutor was talking about. Talking about silencing Kirkpatrick, the witness who testified to that said, I didn't believe she actually intended violence. The state's expert, who clearly was important on sentence, relied on Kirkpatrick's testimony. And the state said several times, state's counsel, the brutality of the crime was sufficient to establish future dangerousness. Legally, it's sufficient, which went to the point we were making that it was a terrible strategy to rely heavily, if not entirely, on future dangerousness in sentencing. But it doesn't mean that Kirkpatrick wouldn't have had a material effect. In terms of your question, Your Honor, about what was known or not known, I obviously can't do that in 6 seconds, but it's reviewed in our brief. A lot of this either was not known or defense counsel undermined it with other evidence in the sentencing case. That's from PM. Thank you for your indulgence, Your Honor.
Thank you. This case is submitted. The court will take a brief recess before considering the next case of the day.
All right. I stop sharing that. Okay, get rid of that. All right. So there you go. There's the oral arguments in the Holberg case. Now, it's a lot to think about. And if you get a chance, go back and watch my show on the Glossop versus Oklahoma, because it was also an appeal, but it was based on the NAPU violations. Anyway, so, I mean, this case just forces some hard questions, right? I mean, what happens when the systems that's meant to deliver justice withholds the very evidence that could change everything? Maybe she would have just gotten life in prison. She admitted to what she did. She admitted that she took his life, right? She did. So she would have been life in prison without parole, I believe, is what would have happened. But that wasn't an opportunity for her because of the Brady violation. Now, in this case of Brittany Holberg, the focus just isn't just the crime. I mean, it's whether that process was fair. And a Brady violation, by definition, means that the prosecutors failed to turn over the defense evidence, the most favorable evidence. So that's not a technicality, actually. That goes to the heart of due process, which we all are entitled to due process. We are innocent until proven guilty. Remember that? Okay. Now, because the standard isn't win it at all costs, you have to be fair. The standard is justice. We have to have justice. The key evidence was withheld. Evidence that could have impacted the jury's decision. Then we're not just talking about a mistake. We're talking about a breakdown in the integrity of the system itself. And here's why that matters. The death penalty is irreversible. There is no do-overs in a death penalty. No second chances once that line is crossed. So whether you believe Brittany Holberg is guilty or not, this question should concern everyone watching. Was all the evidence put on the table? Because if the answer is no, then the issue is bigger than one case. It's about whether the rules designed to protect the accused are being followed when it matters the most. And death penalty cases matter the most. The court will ultimately decide what happens next, but public awareness matters. Scrutiny matters. And accountability matters. Okay? So, I want to hear from you guys. If you are watching it later on and you're over in the replay section, which is great, just put it down. Do you think the Brady violation should automatically trigger a new trial in a capital case? Just put it out there, yes or no. I might put a poll out there to see and to get people to answer it. So drop your thoughts in the comments. And if you're following the cases like this, make sure you subscribe, because we're going to go digging into other details and other cases. And and not all these cases make headlines. That's the thing. They're not all headlines. They're not all high profile, but they all matter. That's what's important here. So until I see you next time, just stay informed and keep asking those hard questions. That's what I'm going to say. You all have a great evening. Be safe out there. Take care of yourselves. Go hug your babies. Life is short. Our time with them is even shorter. So I'll see y'all tomorrow. Have a good evening. Bye-bye, guys.